Number 2.
Yes, sir.
Why? Why?
Your Lordship, the conducting counsel is on legs. She's having a hearing in court number 4.
Your Lordship, I have no objection.
On pre-made by the petitioner. This is matter up to 3 weeks.
Much obliged, Your Lordship.
On supplementary list, item number 1.
Yes.
Lordship, we have taken steps upon respondent number 2 on 11 June. Service on respondent number 2 is awaited, Lordship.
Not yet received. Yes, so what
Lordship,
do we do?
need a matter to be listed after 6 weeks.
Why 6 weeks? 2 weeks is good enough.
Lordship, 4 weeks.
Miss,
I am appearing on behalf of Mr. B.K. Singh.
it's okay. Yeah, Miss S. Sarma.
Yes, Lordship.
Your name is S. Sarma?
Yes, Lordship.
Heard Miss
S. Sarma.
Heard Miss S. Sarma, learned counsel for the appellant, who has submitted that notice upon the respondent number 2 has been issued. However, till date, no report as to whether the said notice has been received or not has been obtained by the appellant. In this regard, it is prayed that some more time may be allowed for a report on the for filing of a report as to whether the said notice was received or not by the said respondent, and for an affidavit of service to be filed for this court. It is prayed that 4 weeks time may be given for this exercise. As prayed for, the same is allowed. You are appearing for?
Respondent number 3 and 4, Your Lordship.
Ms. Learned Counsel is present on behalf of respondent number 3 and 4. Accordingly, list this matter after 4 weeks.
Obliged, Lordship.
Item number 3.
This is under 115.
My lord.
Excuse me. Yes, Mr. Sen.
Please, lordships. Lord, on an earlier occasion, I had given your lordships a very brief outline of the dates and what the gist of the case was. I'll just refresh that, my lords. The respondent herein is a plaintiff who has filed a suit for declaration, recovery of possession, and other consequential reliefs before the court of the assistant district judge. In that application, I'm for the respondents. I had filed an application under Order 7, Rule 11, praying for rejection of the plaint on the ground that it did not disclose a cause of action and it was patently barred by limitation. The court heard the matter and was pleased to dismiss my application. Now, briefly put, what's happened is that the respondent claims to be the owner of a property, a landed property, and apparently sometime in 1988 to 1993, he claims that he received some information that there was an encroachment in the property, and the encroachment apparently was committed by the PWD department, that is the petitioner before your lordships. He did not file a suit. However, he pursued the matter with the DC, the Office of the Deputy Commissioner, where he prayed for a survey. Now this went on, and then finally, sometime in 2010, he approached this honorable court by way of a writ petition. This writ petition was allowed in his favor. However, it was set aside in an intra-court appeal, and thereafter he approached the Honorable Supreme Court as well by way of an SLP. The SLP was rejected. Now, even thereafter, he did not file any suit. The suit was ultimately filed in the year 2023. So there is a large gap, an inordinate delay, which he has to reconcile. Now, in the main suit, there is a clear averment by the respondent that his suit is barred by limitation, and he is, however, entitled to the benefit of Section 14 of the Limitation Act, where some proceedings can, the period can be excluded if it is a case where the proceedings have been pursued in any court. Now, it is our case that Section 14 does not apply. However, none of these issues were actually considered by the learned court below. The learned court below passed a very cryptic order and, without assigning very good judicial reasons, dismissed my application. And that is why we are before your lordships. Now, as your lordships are aware, for the purpose of exercising jurisdiction under Order 7 Rule 11, the court is only required to confine itself to the plaint, the averments in the plaint, and the documents that are enclosed along with. The court cannot look into any external material in the form of a show cause or a written statement or any other supplementary submissions or statements that may be made by the plaintiff to improve his case. So for that purpose, my lord, it will be necessary that I take your lordships through the plaint. My lords will kindly have page 49.
Yes.
My lords will find the details of the parties at page 49 and page 50. Then please see the cause title at page 50 right at the bottom. Suit for declaration, recovery of possession, permanent injunction and other reliefs. So the primary relief sought here is first for declaration, then for recovery of possession, and this is relevant as we go forward. Then at page 51 and para 1 and 2 is some literature about the parties. Then please see page 52.
Yes.
May I read, my lord? That the above mentioned plot number 18, European Ward, Shillong, Meghalaya, was acquired by the plaintiff in a family arrangement from his maternal aunt, Srimati Sitiman Savian, by registered gift deed dated 8/1/1990 and was mutated to the plaintiff's name by order dated 5/7/1990 of the Extra Assistant Commissioner Revenue Shillong in mutation case number 19 of 1990. The mutation order specifies that the plot of land measures more or less 1 acre at the European Ward covered by 99 years lease. Now, this has been emphasized by the plaintiff himself, and this is also relevant as we go forward. So it says more or less 1 acre. It does not really specify the actual area of the property. The area of the property being 1 acre is also stated in the original lease dated 8/6/1895. The boundaries of the property as per the original lease deed and mutation order are set out in Schedule A below. So the reference to this whole area of 1 crore or more or less 1 acre is with reference to the original lease agreement of 8/6/1895, as far back as that. Then please see the next page. That the plaintiff also possesses a private survey map of plot number 18 dated March 1949. This is a private survey map, not conducted by any government authority. The boundaries of the plaintiff's property according to the said map are given in Schedule B below. That while some of the writing at the center of the map of 1949 is faded, the narrative appears to state site plan showing the land of Ka Hinimon, maternal grandmother of the plaintiff, and a predecessor in title near Pine Mount School, Shillong, land area so-and-so, surveyed by B.S. Thapa, Lower Morecambe, Shillong. By way of verification, the length of the boundaries in the said map gives a total area calculation of 59,274 square foot as set out in table 1 below. The difference in area between the map narrative showing 59,280 square foot and verification calculated at 59,274 square foot is a mathematically insignificant 6 square foot. The said map of 1949 has been commissioned by the plaintiff's clan for the purpose of seeking regulatory approval for the building of servant quarter on the property, ostensibly at the request of Pine Mount School, Department of Education, Government of Assam, subsequently Government of Meghalaya. This was because the property had been rented out by the family of the plaintiff to the Pine Mount School in the year 1949. The property continued in the possession of the Pine Mount School until it was finally handed back to the plaintiff on 4/10/1997, that is about 7 years after the mutation order dated 5/7/1990 was passed. That deed of sale dated 28/3/1991, the plaintiff sold a portion of his plot number 18 at measuring 6,700 square foot to the pro forma defendant number. This should be 3, my lord. And this has been corrected before the learned trial court. This portion that was sold was subsequently registered as plot number 18A in the revenue record. So there was some sort of a sale that had occurred in 1991, reducing his property. That in the interim, now this is where the actual narration starts, that in the interim, whilst the plaintiff was away on central deputation with the government of India between the years 1988 and 1993, and whilst the property was still in the possession of the Pine Mount School, the plaintiff began receiving reports from his friends and well-wishers that there were encroachments on the property from the end of the PWD quarters on plot number 19 adjoining the southern boundary of the property. It is clarified that in the original lease deed dated 8/6/1895 granted to Babu Jeevan Roy, that is the plaintiff's maternal grandfather, as well as the mutation order dated 5/7/1990, the area where PWD quarters are currently located were shown as southern boundary of plot number 18, while the more recent revenue records and survey maps show the same as the western boundary. It may be further pointed out that unlike in the more recent revenue and survey documents, the original lease deed and mutation order do not show any other plots as directly bordering the property. The above difference in the record of the boundaries between the old and new revenue records are set out in Schedule C below. The map of 1949 also shows that the plaintiff's plot number 18 is bounded by the bounded to the south by municipal land, which is consistent with the original lease deed dated 8/6/1895 and mutation order dated 5/7/1999 that show the same boundary as adjoining a proposed government road. That on his return to Shillong in the year 1994, the plaintiff immediately addressed a letter dated 20/5/1994 to the defendant number 3, requesting that his plot number 18 be surveyed so as to properly determine and fix its boundaries. The defendant number 3, via letter number so and so dated 14/7/1994, accordingly directed the defendant number 5 to survey the property. To the complete astonishment of the plaintiff, the resulting survey map dated November 1994 of the Directorate of Land Records and Surveys purported to show that as per the existing boundaries, the plaintiff's property stood at 0.780 acres, that's 33,976 square foot, a sizable 0.220 or 9,583.2 square foot short of the 1 acre owned by the plaintiff under the lease deed dated 8/6/1895. That the above DLSRS survey map confirmed the reports of encroachments on the plaintiff's property from the side of the PWD quarters. The plaintiff accordingly tried to mutually resolve all the matters with the officers of the defendant number 1, but to no avail. On the other hand, on 4/4/1997, while on visit to the property, the plaintiff noticed fresh encroachments on the property from the side of the PWD quarters, which was evident from fencing around the area encroached by the defendant number 1. Now please just note here, my lord, that 93, the respondent finds out about the encroachment. He writes a letter in 1994 asking for a survey. In November 1994, the survey report indicates that there is a shortfall, alleged shortfall. The respondent does nothing about it. And then thereafter, in 1997, he visits the property again.
The shortfall was because of the sale.
We don't know. This cannot be ascertained by anybody. It is the respondent's claim now that we are responsible for the
Because in
shortfall.
the meantime, you said an area of about 6,000 or
Yes,
so.
it was sold off. Correct, my lords. These are all very relevant facts. So the original land parcel was reduced because of a sale in 1991 itself. And the respondent claims that the first time he learnt of this was sometime during 1998 and 1993. So this is very strange. So there has been a sale to a third party. Now that shortfall could be a result of that as well. Now we really don't know whether we can actually rely on the records of 1895 and how far that was correct. In fact, this honorable court, while dealing with this matter in the honorable division bench, had recorded that there is no specific area mentioned. It says more or less 1 acre. It could be more, it could be less. How much less and how much more is anybody's guess. So what your lordships will then find, although in 1994 November, there was some confirmation with regard to a shortfall. We don't know how, but there is a shortfall apparently.
You see, when we discuss about the term more or less,
My lord.
as regarding, an area,
Yes.
or boundaries of a land. What does it signify? Does it specify that the difference could be about 1 feet, 2 feet, 10 feet, 100 feet?
This again, Manoj, I was not in a position to really comment. This was none of this information was actually before any court till today.
No, we have to rely on common practice then.
Yes, we have to rely on documentary evidence and whatever subsequent surveys there may be, which is why the respondent had undertaken these survey exercises. And as a result, we have different and very inconsistent reports from the surveys. Now, the first survey report of November 1994 indicates that there is a shortfall, considering that they had 1 acre, more or less, whatever it may be. But in November 1994, for the first time, the survey report indicates that there is a shortfall. Now, your lordships have seen the antecedent facts that in 1991, there had been a sale. So we really don't know. Nobody can for certain say that the shortfall was not on account of that particular sale. It could be anything.
Okay.
But what is relevant, my lord, is the approach of the respondent in approaching the court. What was his intent and whether he wanted to really exercise his legal rights. So in November 1994, as your lordships have recorded, have noticed that there is a survey report which indicates there is an alleged shortfall. From 1994, it was incumbent upon the respondent to approach the court or take some legal steps. Nothing is done. What your lordships will find at para 9 is that, I'll just read out para 9 again, that the above DLRS survey map confirmed the reports of encroachment on the plaintiff's property from the side of the PWD quarters. The plaintiff accordingly tried to mutually resolve the matter with the officers of the defendant 1, but to no avail. On the other hand, on 4497, while on visit to the property, the plaintiff noticed fresh encroachments on the property from the side of the PWD quarters, which was evident from the fencing around the area encroached by the defendant number 1. So from 1994 November till 4/4/1997, no steps were taken by the plaintiff, knowing very well that there is some sort of an encroachment. The plaintiff immediately brought these fresh encroachments to the notice of the defendant number 3, vide his letter dated 5/4/1997, and for the second time requested the defendant number 3 to depute the latter's officers to demarcate this boundary of the property, which had quite obviously been tampered with. That the defendant number 4, vide letter number so and so dated 15/4/97 and 15/5/97, subsequently directed the defendant number 5 to conduct a survey of plot number 18 on the basis of a proposal for acquisition of Norris Bungalow by the Education Department. It may be mentioned here that this attempt by the government to avoid handing back plot number 18 to the plaintiff never materialized. The defendant number 4 has also made categorical statements in his above mentioned letters respectively that the legal position as per the records available with his office was that plot number 18 belonging to plaintiff is 1 acre, out of which an area of 6,700, which the plaintiff had sold in the year 1991 and was marked as plot number 18A, has been transferred to Shri Pardunan Kumar Singha, leaving an area of 36,860 square foot, and that, as per our records, the area of Shri BKD Savian is 36,000 square foot, and that of PWD is 0.233 acres, that is 10,149.48 square foot. The defendant number 5 was requested to conduct the survey on the basis of these observations. That on or about July 1997, the office of the defendant number 5 undertook a survey of both plot number 18 belonging to the plaintiff and plot number 19 in the occupation of the defendant number 1. The resulting DLRS survey map purported to show that as per the existing boundaries, plot number 18, excluding plot number 18A, measured 0.672 acres, that's 29,272.32 square foot, whereas plot number 19 of the defendant number 1 measured 0.444 acres, that's 19,427.76 square foot. This survey indicated that the defendant number 1 had encroached upon between 0.174 to 0.233 acres, that's around 7,588 to 9,278 square foot of the plaintiff's property. That the plaintiff had once again brought these various discrepancies to the notice of the defendant number 3, vide his letter dated 2/8/1997, the plaintiff's third such letter. The defendant number 4 was pleased to take immediate cognizance of the matter, vide his letter number so and so dated 2/8/1997, wherein he acknowledged the full extent of the discrepancy and for the first time made an unequivocal observation that the plaintiff's plot number 18 has been encroached upon either from plot number 17 or plot number 19. Now, please note this, my lord. It says the observation was that the plot number 18 belonging to the respondent has been encroached upon either from plot number 17 or plot number 19. There is no certainty here again. The defendant number 4 also once again gave a clear direction to the defendant number 5 to survey and demarcate plot number 18 measuring 36,860 square foot on the ground, keeping the area of the land intact to the extent possibility. That on 30/9/1997, the officials of defendant number 5 proceeded to demarcate the boundaries between the plaintiff's plot number 18 and the plot number 19 in possession of the defendant number 1. However, the resulting survey map dated 22/10/1997 measured plot number 18 and 18A collectively at 0.890 acres and plot number 19 at 0.390 acres. Subtracting the 6,700 square foot of plot number 18A, this left the plaintiff's plot number 18 with an area measuring approximately 0.736 acres or approximately 32,000 square foot as opposed to the 36,000 specified by the defendant number 4. A bare perusal of the 22/10/1997 survey map reveals that the marginal improvement in the plaintiff's acreage therein when compared with the earlier surveys was on account of the defendant number 5 for the first time creating an artificial indentation in the plot number 18's western boundary with the plot number 19 in a manner which suggested a desire to leave the quarters of defendant number 1 on the encroached portion of the property undisturbed. It may be mentioned that in all earlier surveys the boundary between plot number 18 and plot number 19 had always been a straight line and not the line with a protruding indentation. In any event, the survey indicated that the defendant number 1 was in unlawful possession of the plaintiff's property to the extent about so and so. Now this is important, my lord, that due to various problems, tragedies in the family, including the persistent illness and passing away of the plaintiff's father, mother and wife, coupled with the plaintiff's exacting professional responsibilities as the officiating DGP of Meghalaya, a tenure with the BSF at different locations in the country, and again as DGP Meghalaya, the plaintiff was unable to pursue this matter in the intervening period. This is an admission made by the respondent himself in the plaint. Meanwhile, due to financial compulsions, the plaintiff had built a wall. Please note this, my lord. The conduct of the plaintiff here. The plaintiff had built a wall around the undisputed 32,000 square foot of the property to prevent further encroachments by the defendant number 1 and sold the same to the pro forma defendant number 2 on or about December 2006. This portion of the property being the subject of a second sale by the plaintiff was marked as plot number 18B in the revenue records. So the respondent admits that despite what had happened, whatever survey reports had come out by the end of 1997, he did not pursue the matter any further, and he gives his reasons. Professional and personal reasons. And then subsequently in 2006 December he sold another portion of this plot of land to a third party. Then kindly come back to page 61, paragraph 15, that subsequently the defendant number 3 issued the plaintiff a renewed lease agreement dated 8/5/2008 for the balance area of plot number 18, which on a simple mathematical construction he determined to be 4,860 after subtracting the 6,700 square foot of plot number 18A and the 32,000 of plot number 18B. So what this essentially means is, despite what had happened in November 1997 and even after the sale of December 2006, he did not pursue the matter before the court. He did not institute a civil suit. Instead, in 2008, he approached the department, the revenue department, and obtained a lease agreement for the remainder of the property, thereby giving up his claims to the rest of the property. And he had already drawn up a boundary wall. Then please see para 16, that via his letter dated 35/2008, the plaintiff for the fourth time petitioned the defendant number 3 to accurately demarcate the boundaries of plot number 18 as also plot number 18A, 18B and 19 in order to identify and restore the missing area of the property on the ground. So what your lordships will find that from December 1997, when there was some semblance of a report, there was no action on the part of the respondent, and for the first time again he seeks a resurvey of the properties is in 2008 in May. So there is a huge vacuum during this period. The survey was notified for 26/8/2008. To the plaintiff's great disappointment, the survey and demarcation report dated 3/11/2008 of the defendant number 5 and DLRS survey map dated August 2008 failed yet again to demarcate the plaintiff's property on the ground. The defendant number 5 instead relied on a flawed ex parte cadastral survey map of 63/64 produced under the Assam administration, which recorded the area of the plaintiff's original undivided plot number 18 as 0.794 acres. So what your lordships will find here, there is an admission that during this exercise of a survey after 2008, the government initiated the survey and relied on a cadastral survey map of the Assam government from 1963-64, which indicated that the plaintiff did not have 1 acre. Plaintiff had a reduced area. The accompanying DL...
That means right from the inception.
No, this is in 2008. This discovery is 2008. So initially they are referring to their original documents from 1800s. And here, during the Assam administration, there is a survey map from 1963-64, which itself indicates that the plaintiff did not have 1 acre. He had 0.794 acres. That's 34,586.64 square foot. This is a part of the plaintiff's own documents, his own plaint. The accompanying DLRS survey map dated August 2008 showed plot number 18 plus 18B as measuring 31,770.83 square foot and plot number 18A as measuring 7,144.32 square foot, whereas plot number 19 was stated to measure 15,109.50 square foot. This survey indicated that the defendant 1 had encroached upon 4,960 square foot of the plaintiff's property. That the plaintiff by his petition dated 24/3/2009 comprehensively laid down all the above facts for the consideration of the defendant number 3 and for the 5th time once again requested a survey and demarcation of plot number 18 and plot number 19, which would identify and restore the plaintiff the area of plot number 18 which had been encroached upon by the defendant number 1. That further, in order to better understand why such simple case of encroachment and demarcation was being inordinately delayed by the authorities, the plaintiff by his letter dated 24/8/2009 to the defendant number 3 requested a copy of the 1963-64 Assam survey, European Ward number 3, European Ward sheet number 3. A photocopy of the official printed copy of the 1963-64 Assam survey map held in the office of the Deputy Commissioner was supplied to the plaintiff by the defendant number 3 by letter dated 16/9/2009, the original 63-64 Assam survey map being held by the DLRS. The original, the plaintiff subsequently had the opportunity to inspect the original map at the office of the DLRS, and upon undertaking a comparison between the original map and the printed copy, the plaintiff noticed the following glaring discrepancies. That while both the original map and the printed copy recorded the area of plot number 18 as measuring 0.794 acres, the printed copy recorded the area of plot number 19 as measuring 0.233 acres, while the original map recorded the same plot of recorded this same plot number 19 as measuring 0.348 acres and excess of 0.115 acres. That a bare perusal of the original map revealed that the measurement of plot number 19 had been arbitrarily increased at a more recent date, which was obvious from the different writing and different ink used in making the new entry of 0.348 acres against plot number 19 in the said map. That these arbitrary changes in the measurement were made in the original map against the recording for some other plots also. The plaintiff brought these discrepancies to the notice of the defendant number 3 by his letter dated 23/9/2009. That the defendant number 3 by his letter number so-and-so dated 10/11/2009 requested the defendant number 2 to furnish the copies of the land records pertaining to plot number 19. That it came to the notice of the plaintiff and the defendant number 1 and number 2 were able to furnish the required documents as requested by the defendant number 3 in the latter's letter dated 10/11/2009, and that therefore the matter was being delayed indefinitely. That the plaintiff by his letter dated 17/3/2009 addressed to the defendant number 4 once again pleaded that the matter be resolved at the earliest possible time. My lord, may just skip this and come to page 66, para 23.
Yes.
Para 23, my lord. that subsequently the defendant number 3 sent a comprehensive report on the matter to the Undersecretary Revenue Disaster Management by letter dated 10/5/2010, wherein the observations of the defendant number 4 at the meeting of 30/4/2010 were reiterated, in addition to a further observation in respect of plot number 18 as follows. I'm skipping this, my lord. I'll take your lordships to the letter subsequently. Please come to para 24. That the above mentioned report of the defendant number 3 revealed for the first time that the defendant number 1 had no title or claim to the possession of plot number 18. In fact, plot number 19 never existed, and only first found mention in the ex parte cadastral 1963-64 Assam survey map, whereas the plaintiff's lease for plot number 18 dates back to 8/6/1895. Further, the above survey of 63-64 was executed while the plaintiff's plot number 18 was on lease and in possession of the government of Assam for Pine Mound School, and the same Assam government did not issue notice to the plaintiff's predecessor entitled that they were conducting such a survey. The report dated 11/5/2010 of the defendant number 3 was discussed in the review meeting of the NLR MP held on 18/8/2010, and consequent upon the discussions, the Revenue and Disaster Management Department, Government of Meghalaya, via its letter dated 25/8/2010, directed the defendant number 3 to re-examine the matter. Now, whatever observations that have been made by the Deputy Commissioner in favor of the plaintiff were not accepted by the government at the higher level, and by this particular letter, the DC was asked to re-examine the entire matter. So this date is very important, para 25. Then at para 26 it reads that the defendant number 4, by his letter number so-and-so dated 16/9/2010, once again directed the Joint Director Surveys Meghalaya Shillong to fix another survey of plot number 18 and 19 on 18/10/2010. The plaintiff travelled to Shillong and remained present at the site on the appointed date and time. However, officials of the DLRS did not turn up. It was later learned by the plaintiff that the defendant number 5 had sent a reply via letter dated so-and-so to the pro forma defendant number 2 stating as follows: the survey of the plots in question has been conducted number of times and the report has been furnished to you via office letter dated 3/11/2008 and letter number 21/10/2009. In this connection, I would request you to kindly clarify the necessity to resurvey the same. Further, it is also suggested that a meeting between the DC and the officers of the survey may first be held before taking up the survey and demarcation of the plots in question. So originally there is a survey report. The matter is placed before the DC. DC somehow gives a finding without any technical expertise whatsoever in favor of the respondent. This matter is then sent up to the higher authorities for their sanction. They refuse to sanction this matter and they direct it back to the DC, asking the DC to re-examine the whole matter. Pursuant to this, the DC sends this entire matter to the DLRS, asking for a resurvey. The DLRS refuses to resurvey and says, you have to give us an explanation as to why you want to survey this property again and again. Then, my lords, come to page 69, para 27. Now, this is important, my lords, under the heading interim litigation. That this, left with...
This refers to those...
whatever litigation he had initiated after 2010. That left with no other recourse, the plaintiff approached the Honorable Guwahati High Court in writ petition number 415 of 2010, seeking various concurrent and alternative reliefs, including mandamus to direct the defendant number 3 and number 5 to implement the findings of the defendant number 3's report dated 11/5/2010, which had been passed after due inquiry. Now, please note this, my lord. His prayer is for implementation of a report of the Deputy Commissioner, which somewhat is in their favor. Now, what has happened is that the DC sent this report for the concurrence of the government. Yes. The government refused and the government sent it back to the DC for a re-examination. Pursuant to that, the DC asked for a resurvey to the DLRS. DLRS refused. So we don't know why, but the respondent decided to seek implementation of this particular report.
But then can the DLR refuse?
Well, so the Revenue Department had refused to accept this report and had sent it back to, remanded it back to the DC for re-examination. Exactly. So once that is done, this report loses significance. It does not stand any further. I can make a report and I can send it for concurrence to my superiors. If my superiors refuse to accept it, it loses significance completely. And this is an interdepartmental communication. A plaintiff cannot come forward and say, I want some sort of a right has flown in my favor on the basis of some sort of a interdepartmental communication. This does not create any right in favor of the plaintiff. Then please see the next paragraph, para 28. That the learned single judge of the Guwahati High Court, in his order and judgment dated 23/9/2011, in the writ petition, directed that the defendant number 3's report finding dated 11/5/2010 be implemented by the defendant number 3 and 5 within 2 months of the date of receipt of the order, after observing at para 13 of the judgment that there is nothing on record to show that the aforesaid conclusion of the DC are disputed by the state respondents. Well, this finding itself was incorrect. The affidavit in opposition is conspicuous by its ambiguity. This left me with no alternative but to adjourn the hearing of the case and direct the PWD authorities to file their affidavit in opposition, which they did subsequently. Even after this, the respondent authorities do not materially improve their case. On the contrary, the affidavit in opposition filed by the PWD authorities appear to be a half-hearted attempt to defend their case but without substantiating their allegations with supporting documents. I am again constrained to observe that no substantial dispute is raised by either the PWD or the Revenue Department on the findings of the respondent number 2 in the letter dated 11/5/2010, nor is the same repudiated or disowned by the remaining respondents. Now this is very interesting because thereafter a appeal is carried forward. Then kindly see page 71.
Yes.
Para 30 minute. That meanwhile, in February 2012, the defendant number 1 filed writ appeal number 2 of 2012 before the division bench of the Honorable High Court of Meghalaya, challenging the above judgment dated 23/9/2011 of the learned single judge. While its judgment dated 21/7/2014, the division bench of the Meghalaya High Court allowed the writ appeal of the defendant number 1 on the grounds that serious disputed questions of fact between the parties come within the realm of private law. The writ petition is not the proper forum for deciding the right claims, and the proper forum would be a civil suit in the civil court of competent jurisdiction. In fact, there are further observations. I'll take your lordships to the judgment. They find that the learned single judge's findings are absolutely without any basis and there is no records for it. So the findings were absolutely misplaced. While rendering the judgment, they go on to make a very specific observation which is very important. They say that the remedy, as far as the plaintiff is concerned, lies by way of a civil suit before a civil court of competent jurisdiction. So what this basically says, he was given an absolute direction, a clear direction as to where to ventilate his grievances. That was by way of a civil suit, not by any other means. Now, pursuant to this, my lords, what's important is the conduct of the plaintiff thereafter. Then please see para 31 at page 72. That pursuant to the above mentioned order of the Honorable Supreme Court, after seeking advice of legal counsel, the plaintiff decided to file a formal application. I apologize, I've just missed out one paragraph, the last paragraph of para 30. The last line of para 30. I've missed that out. The fourth line from the bottom, my lords.
Yes.
That in the subsequent SLP number so and so of 2014 filed by the plaintiff, the Honorable Supreme Court, by its order dated 12/5/2014, agreed with the division bench of the Honorable High Court. So the SLP that was preferred against the judgment of the division bench was rejected. So the findings remained that his remedy was before a civil court by way of a civil suit. So pursuant to this, my lords, please have page 31, para 31. That pursuant to the above mentioned order of the Honorable Supreme Court, after seeking advice of legal counsel, the plaintiff decided to file a formal application dated 11/8/2015 under section 23C of the Assam Land and Revenue Regulation 1886, read with para 8 of the plaintiff's lease agreement before the defendant number 3 in the latter's capacity as a quasi-judicial court of fact in such disputes involving revenue land. And please look at this last line. The plaintiff in his earlier letters, these earlier letters meaning the letters from 1994 onwards, where he had sought a survey, the plaintiff in all his earlier letters had approached the defendant number 3, that is the DC, in the latter's administrative capacity only. He goes on to say that despite the order of the division bench, which stands confirmed by the Honorable Supreme Court, he chooses not to file a civil suit. Instead, he moves an application under section 23 of the Land and Revenue Regulation, which basically governs settlement of boundary disputes. And here, he makes a clear concession and admission that prior to this, when I had approached the DC it was in the DC's administrative capacity, not in his quasi-judicial capacity, and this is very important, and I'll show why this is relevant as we go forward. Kindly mark that, my lord. That once again the matter remained inordinately delayed with the defendant number 3 despite the plaintiff's repeated pleas for expeditious disposal, forcing the plaintiff to approach the Honorable High Court of Meghalaya again in writ petition number so-and-so. The Honorable High Court in its order dated 16/4/21 in the said writ petition directed the defendant number 3 to dispose of the plaintiff's application under section 23 of the so-and-so within 2 months from the date of the order. That when the plaintiff number 3 failed to comply with the order, the plaintiff once again approached the Honorable High Court of Meghalaya in contempt case number so-and-so. The plaintiff fatigued with 27 years. Please note this, my lord. This is very important. The plaintiff fatigued with 27 years of delays and litigation. This is very important. 27 years. And now being of advanced age, also sent a without prejudice offer of settlement dated 21/6/2021 to the defendant number 2, to which the plaintiff never received a response. And also please note, my lords, that at para 31, he has made a mention that he filed an application under section 23 of the Land and Revenue Regulation. However, we do not have the benefit of that application. It was necessary that it should have been enclosed. It's a material document, and what are the prayers are very relevant as well, but this has not been enclosed.
No, okay. Let us pause here for a while.
My lord.
At this stage, you see, the plaintiff had stated that he is ready for
Yes,
settlement of
at para
reconciliation.
33, yes.
Why it was not responded to?
That I'm not really sure. That is a decision that they would have taken.
That would have been a, that would have settled the matter once and for all if any settlement could have been reached.
What I understand is that he had approached the Honorable High Court, single bench. The learned single bench had passed an order in his favor. That was finally overturned by the division bench of this court. Thereafter, what lay before him, the option that was available to him was to assert his right that this particular area belongs to him, whatever the disputed area may be, by way of a civil suit. He chose not to. He instead moved an application under section 23 of of this particular regulation. While that was pending, because he claims there was some delay, he moved the Honorable High Court as well. The High Court made a direction to dispose of that application within 2 months. It was only thereafter that he made a reference to the pending proceedings, asked for a settlement, amicable settlement of the matter. The department perhaps did not want to. Amicable settlement would mean that they would have to part with whatever area concerned.
See, but in this, you see, in the larger scheme of things,
My lord,
that would have been a better option.
they refused, my lord.
Whether mediation
Yes.
or settlement is prevalent as far as civil suits are concerned.
Yes, absolutely, absolutely. If the parties agree, the parties can always be sent for mediation.
I
But in
think
this particular case, this relates to 2021, my lord.
whatever the case
Yes,
may be,
yes, I
whatever-
understand.
Leave aside the the facts and circumstances.
Lordship,
If the party, even at this stage,
my lord.
are agreeable,
Lordship.
that could have been sorted out.
I'll have to take instructions for that.
Lordship, I believe there was a reshuffle of officers, and the letter went to another officer who didn't have jurisdiction anymore in of that department. And I think the matter ended there.
No, because you see, this court coming to know of this averment
Lordship.
would at this point of time, if it is agreeable to the parties,
I'll have to take instructions.
may refer the matter for mediation.
That I'll leave it to
As
you,
we all
Lordship.
know, you see, a litigation of this sort,
My lord.
it will go on. It
Lordship.
will go on.
Lordship, we're prepared. In fact, our offer is still on record. So.
No, we forget about what has happened.
My lord.
We start on a clean slate.
Lordship.
We can make an attempt.
Start on a clean slate, based on your plea, and whatever documents or whatever evidence you have in your
Lordship.
with you, and let the authorities decide if they can. You see, if I don't know, if I'm made to understand, it is just a question of a boundary dispute.
Correct.
Lordship.
Correct.
Boundary dispute, like you said, you see, there can always be a give and take,
Lordship. True.
and that would settle the matter once and for all.
I'll leave it up to you,
If
Lordship.
the plaintiff has
Made an offer earlier.
yes, made an offer,
Lordship.
being wary
Lordship.
of the matter which has traveled for almost 27 years or so. Maybe something could be done.
I have no objection to that, man. I'll leave it to you,
I
Lordship.
think at this point of time, perhaps.
We are amenable, Lordship, of course.
In the scheme of things, your lordships find that there is a possibility of a settlement, lordship may refer it.
See, like you said, there is always a scope for settlement.
Lordship.
It's just a question of shifting boundaries here and there.
I'll leave it to lordships. I can't take the decision. Attempt can be made. There's no
What do you
difficulty.
say?
Lordship, I'm amenable. I'm not sure if the petitioner might be amenable,
I
but
can't
we
make a
certainly are,
statement.
Lordship.
Lordship may refer the parties. It's for them to decide.
True. Because it's not for, of course, the council will just advise,
Lordship.
but it's the decision of the parties.
Of course.
Mediation means what? It's the parties themselves who will
Have to sit and
who will settle a
negotiate, of
matter
course.
amicably across the table.
Usually, if it's before a trained mediator, parties tend to oblige.
No, we have a mediation.
Yes,
cell.
yes, my lord. Correct.
We have trained mediators.
Yes.
We have referred many matters.
Correct. Which have also been settled also.
Which have been settled.
Lordship. I'll leave it to lordship. If your lordships find at this point that there is a possibility,
There is.
lordship. I'll leave it to lordship.
We're amenable, Lordship.
Yes, Mr. Pillai?
But then, my lords, in the meantime, lordship will have to protect my civil suit.
No, that will.
The interim order may kindly be extended.
Interim order will remain in
My
force.
lord.
Let the mediation continue.
Correct. Okay.
Mr. D, you do one thing. I'm not saying that I'll refer the matter as of right now. You consult your client
Lordship.
and you consult your father, and then we'll see.
My lord.
Lordship.
Come back tomorrow.
All right. Very well.
Please, Lordship.
Right. Tomorrow's fine.
We need more time to do.
I may need a little bit more time because for them to consent to something like this, it has to go to the department. In case the concerned person is not available, lordship will then have it either on Friday or on Monday. Because for my friend, it'll be easier. For my friend, it's easier to get
I'm amenable,
instructions.
Lordship.
For
I
me, it's a little
understand
difficult.
he'll take a little bit of time.
After a week is also fine.
You suggest a date.
8th is fine.
That's fine.
Sorry.
16th.
Because if that proposal has to go to the department, your lordship,
My lord.
because it has to go from one table to another table, your lordship, it will take a lot of time.
I will pass an order to that effect.
Lord.
The council will, serve the order upon the authorities concerned, and it's for them to decide.
My lords, if it's in your lordship's order today, then I'll take a copy of the order and formally send it to them. So then kindly give me 2 weeks then. Because I have to send it to them. Even by Monday, it may not be possible for them to take a decision.
Agreed, Lordship.
16th is also fine.
16.
Lordship. Just to come back with instructions, my lord. Lordship.
Because you see, if it is agreeable, then we proceed.
Yes.
If not, then we
Continue.
Continue with the hearing.
Of course.
heard Mr. SN, Lorette G, for the state petitioner.
For PWD, your lordship.
PWD.
Because here also,
Oh.
the commissioner also have parties, your lordship, 100%.
But I'm relying on all their documents, Lordship, to prove my case.
That's another aspect of the matter. Which, for the then you are appear as special counsel then.
Oh, my lord, in this case, I was representing PWD. Can you see the name of the petitioner?
Exactly.
It's the Commissioner Secretary of PWD. Because here the Deputy Commissioner's office plays an independent role.
Why would the Commissioner and Secretary PWD come in his official capacity?
He's made a party in the civil
I
suit.
made them a party in the civil suit,
The
Lordship.
defendants in the suit.
More or these officials are always made parties,
My lord.
but eventually it's the state who takes care of,
Lordship. So
of
the
their of their stand or right or. Right, anyway, we'll see. Lorette G appearing for the petitioner PWD. Also heard Mr. ASD, Lorette counsel for the respondent number
Number one.
and Mr. Indishulai, then AG for
2, 3 and 4.
respondent number 2, 3 and 4. 4 respondents. Yes.
There are performers as well, they're not appearing well.
Mr. Sen has Mr. Sen in his preliminary submission while opening the case of the petitioner has led this court through the plaint filed by the respondent number 1, which is the subject matter of the dispute herein. However, in the midst of such hearing, this court is of the opinion that at this point of time, perhaps the matter could be resolved amicably between the parties if they are agreeable to subject themselves to the mediation process. The letter counsel for the respective parties has submitted at the bar that they are inclined to the suggestion made by this court and would require some time to consult their respective clients so as to get their consent or otherwise. This being the case, this court would allow the parties to approach their clients and to come back with a reply as to whether the parties are agreeable to a settlement and agreeable to bind themselves, not bind themselves, to this matter being taken up through the process of mediation with a trained mediator conducting the proceedings. Accordingly, on premier, this matter for this is matter on 16th for further orders.
Once the interim order may kindly be
In the
extended.
meantime, as before, the interim order will remain in force till the next returnable date or until further orders.
Highly obliged, no?
Grateful, Lordship.
Try and
Lordship,
because
Lordship.
in fact that should have been the offer that should come from the parties in the first instance.
Lordship.
And if mediation fails. See, mediation, it doesn't mean that it binds the parties.
My lord.
You are always free to settle, negotiate, and if it fails, even that process is not taken into account as far as the proceedings are concerned.
Absolutely, Lordship.
So no record is made of whether mediation has failed,
Lordship.
who is responsible. That is not there.
It's without
The
prejudice.
mediator would simply file a report, mediation not successful, mediation successful, and so on and so forth.
Lordship. Lordship.
So that is the process of mediation, if you can understand it.
Lordship.
Grateful, Lordship.
My Lord, item number 6. I'm not ready with the written argument, my Lord. I'm praying for a week time, my Lord.
See, you have to answer only one point. You have to answer only one point. He is seeking leniency. What else?
But that is absolutely correct, my Lord. But as per the last order, I'm required to file the written argument.
On premier by Mr. R. Gurung Lanerji, this is matter after 1 week.
May I please, Your Lordships? Your Lordship, I beg to mention item 3, Your Lordship. I'm praying that the matter may be listed after 2 weeks. I've already taken consent, Your Lordship.
On premier by Miss. You're for your legal aid counsel?
Yes, Your Lordship.
Picture 3 Learned Legal Aid Counsel, matters adjourned. This is after 2 weeks.
Oblige, Your Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 5, Your Lordship. Lordship, I humbly pray for some accommodation in this matter, Your Lordship.
Service matter?
Just mention fixation of some
Right,
pay
pay scale,
scale.
Your Lordship.
Any objection?
A number of times my colleague has taken denial. There is a denial. Other counterpart employees, they are enjoying all this. They have to deny this.
So,
Lordship fixed the matter after 2 weeks as a fixed matter.
you cannot just keep on adjourning matters like this.
Lordship, I pray 3 weeks, Your Lordship.
It's a fixed matter subject.
No more adjournments.
Yes, Lordship.
On premier by Ms. K. Gurung for petitioner, Union of India, matters adjourned. This is after 3 weeks.
Much obliged, Lordship.
Item number 4, my lord, I've heard this matter. You also heard this matter.
It was regarding to the retrial, Your Lordship. We had a lengthy hearing last Wednesday on the issue with the
Denial of fair trial.
Okay. That where
Yes.
cross-examination is.
Yes, my lord.
on the basis of cross-examination. My learned friend relied on some judgment. I also relied, Your Lordship.
So it is there in the hearing list today, my lord, at
Number
item
four.
number 4.
So Lordship may
It's not even shown as a part hard matter.
What does the order says? Order?
Well, the order I will say is
for orders.
heard the appellant. It's fixed for further orders, my lord.
We did not list it for orders, but on premier by the parties, list is matter of 2 weeks. So I think since we have heard the parties,
My lord.
no specific order was, is there for orders to be passed.
Lordship.
So,
And after the order, eventually, what will happen, Lordship?
list this matter after 2 weeks for orders.
Obliged.
Whether we can send the matter for trial.
Daily list, item number 1.
Lordship, item number 2 is the appeal arising out of the same impugned judgment, Lordship, in item 1.
Yes, so
And Mr. Shulai is appearing as well.
Mr. Manta is in both cases.
No, I'm in one, number one.
And who's in two?
Earlier I have
Item 2, Your Lordship, Mr. Sheikh is there as a counsel, Your Lordship. I forgot.
But Mr. Manta, you will have your own grounds. He will have his own ground.
Yes, certainly.
ground. In fact, I have read the evidence and the common intention, how the court has arrived at. Your Lordship, to that effect, I have little say. And the DWs, Your Lordship. I stop at the DWs. And the court, Lordship court below what happened, say the DWs are unreliable.
So we will continue with Mr. Manta's case.
Number one.
We'll see how it goes.
Lordship.
So, with regard to the DWs, I have stopped that day, Your Lordship.
Yes.
So, if Lordship permits me to once again go into the DWs.
Yes.
Where's the DW? DW. No, this way. Ahead. Oh, I know. 313. Yes. Also, page 78.
78.
Page 78. 78. This is very important for me, DW1.
Yes.
Again, I'll just go into that. I have come to depose as a witness in connection with the Hala in the village. I and Abdul Okil, one of the convict now, I and Abdul Okil were walking together at Magalpara in the Pineapple Garden. When I reached Chibinang Bazaar, along with Abdul Okil, after cutting pineapple, we heard that there was a Hala in Khalitan Bazaar. That's the chief. And across it comes, Your Lordship. At the time of the Hala, I was as Magalpara along with Abdul Okil. So it proved and established that at the time of the incident, he was with my convict in Mangalpara. It reaffirmed that. Also in the
Incident happened?
Incident happened.
Chibinang Bazaar.
Yes.
And this Chibinang Bazaar?
Not Mangalpara. Incident happened at Khaitan Market. Khaitan Market, there, Your Lordship. So, Magalpara along with Abdul Okil and few other walkers. I did not see the Hala, but I only heard about it. At the time of incident, I was cutting pineapples, and at the time I was not aware of the Hala. I do not know where Abdul Khalil. This Abdul Khalil is the father, who is represented by Mr. Sheikh. And Jahinur. Jahinur is another convict whom I am representing. He said, I do not know where Abdul Khalil and Jahinur Islam were at the time of Hala. Obviously, since Jahinur was not with him, only Okil was there. So he doesn't know where is that Jahinur. And the learned court say that since he doesn't know where is Jahinur, so these are unreliable witness. I'll come into the judgment. Khalil, where at the time of Hala? I did not go to the place of Hala, although I heard about it, but went straight home. Abdul Okil was with me at 11 a.m. and both of us went home. Later on, I heard that the Hala was between Abdul Khalil and other parties, which I do not remember. It was during the time of Roja. So, learned court below said, since he said that he is with Abdul Okil, this DW, this proved and established. Even in the cross also it has been reaffirmed that I am in Magalpara. So, my implication by the witnesses was false, Your Lordship. But the court below say that this is unreliable evidence. So that is wrong. I'll come into that. Now the next DW, Your Lordship, will come, DW2 at page 79. I came to depose as witness. I know Jahinur Islam as he is a pickup driver. And to the effect there is no cross, Your Lordship. We'll see that. On that day, we hired pickup driven by Jahinur Islam and went to pineapple farm to collect pineapples. It was in the month of Roja. I do not remember exact date, month and year of the incident, but it was on Tuesday. And the trial court below said, since you do not know month, time, date, so you are unreliable witness. And the Supreme Court says that those rustic villagers, we have to ignore those. They may not remember everything. After collecting the pineapples, we went to Rangsai, Chibinang side to do business. After selling pineapples at Rangsai market, I heard about the incident through other people in Chibinang Bazaar. Now the cross, very important. Around 4 a.m., I hired a pickup of Jahinur Islam from Chibinang to Rangsai. I can reaffirm that I am from Chibinang to Rangsai with this. But trial court says is unreliable. I, along with handyman Mukul and driver of pickup Jahinur Islam, went to Rangsai to collect pineapples. Later, around 10 to 10:30 a.m., I sold the pineapple at Chibinang market. Later on, I also heard that there was a hala at Khalitan market. The distance from Chibinang to Khalitan market would be around 1 kilometer. This is very important. 1 kilometer. There were also houses near the Khalitan market which were located closely to each other. I do not know anything about the hala and which the hala has took place. So to this DW said that they are unreliable. So accused, the convict was really denied, it has been prejudiced by the court below. Because the court said a common intention means, where is the common intention? I was never with the father and the son in the marketplace. No one has seen us, the father and the son in the marketplace. There is no evidence to that effect. That I ran along with them chasing the disease. No, nothing. Because both this, my convict, they were in different places, Your Lordship. That has been established, the plea of alibi has been established, Your Lordship, and proved and reaffirmed in the cross. So that is very important for me, Your Lordship. And the court below, how it says, Your Lordship, I'll just come to that part. Later, after the submission made by the prosecution, I can come back to the whole judgment, Your Lordship. Now, for the moment, if Your Lordship is pleased to turn to page 104 of the judgment, page 104 of the judgment. But Your Lordship got that, page 104 in the paper book of the judgment. May I read that? Paragraph 31. Evidence of DW1 Bokul Haq is not reliable, as he has stated that he doesn't know where Abdul Khalil and Jahanur Islam. Obviously, Abdul Khalil and Jahanur Islam are not with me. So where they? How I'll know? Then how I can be held unreliable? Where at the time of the incident, Hala, he also admitted that later on he heard that a commotion was between Abdul Khalil and other parties whom he doesn't remember. He has mentioned that he has not mentioned the time of incident. Your Lordship, since I failed to mention time of incident, therefore I become unreliable. And 32 page, Your Lordship will see. Evidence of DW2 Nazrul Sheikh is also vague, as he has not mentioned the date of the incident, as he has stated that he doesn't remember the exact date, month and year of the incident, but it was on Tuesday. Therefore, he becomes unreliable. DW2 does not know anything about the incident with whom the incident took place. Obviously, I was not there. How I'll know about the incident? I was with the convict. He was there in another place. How will know about the incident? So how will it become unreliable? So this way completely wash away the DWs. That's unjust, unfair in the judgment. And other part which I have, again I'll reiterate, Your Lordship, that other parts of PW 1, 2, 3, 4, Your Lordship will see that only 2 persons entered the room. Though they try to implicate us in the cross, sometimes they say no. And court took very heavily the dog identification. But in the TIP, nobody identified us. They identified only Khalil, not us. They identified only the father, who is convicted. So not both of us, Your Lordship. And in the dog identification taking that they have identified us in the dog, so that we are having a common intention to attack. So we are held liable for life imprisonment, Your Lordship. And as Your Lordship knows, the dog identification is no identification, and it is not admissible until it is corroborated with some other evidence. This is the law, established law. So these are, in summary, my case, Your Lordship, that I have been roped in very wrongly in this case. And Your Lordship will see the judgment, 34 has been defined, intention, common intention. What is my common intention in this case? I am not in the place itself, Your Lordship. And the purpose, what happened, Your Lordship will see that the counsel originally, Mr. Majumdar, who was there, although with due respect to him, he has been left out. A state defense counsel has been given, Your Lordship. And as Your Lordship knows, so difficult is so, lot of year has been denied to us, Your Lordship. And however, Your Lordship, the judgment, there are many other things in the judgment, that common intention, there is nothing to implicate that where we have pre-planned, we have an intention to go and attack this man. There is no indication in the marketplace who has seen us, nothing is there, no evidence come forward, Your Lordship. Just they implicate that, oh, we are standing outside. How is standing outside, Your Lordship? We didn't even know that, we didn't even follow, we didn't even go there. Just implicate us with this. Just a dog identification and are making the DWS unreliable. That is unjust, Your Lordship. That's my sum up here. And other things I'll just come into after the event.
Yes.
Lordship, during the trial, Lordship, there are 8 witnesses, altogether 8 witnesses. And PW1 is the complainant. PW2, PW3 and PW4 are stated to be the eyewitness. PW1 is the complainant, and in his deposition he stated
2, 3 and 4 are eyewitnesses.
They are stated to be eyewitness, 2, 3 and 4 eyewitnesses.
Yes.
PW1 is the complainant, and the complainant has stated, he has mentioned all the 4 accused persons. And the victim who was attacked at the first instance in Khalitan market, and he managed to escape and he ran away. And all of 4 of them, they were chasing the victim, and he entered one house. And these 4 accused persons also, they entered in the house, and there they assaulted him and he was killed.
So the first incident happened at the market.
At the market. From there he managed to run away.
And where did he reach?
He reached one place near, it's the...
What is the name?
The house of a relative. He entered the house of his relative.
What is the area known as?
It's nearby the market.
Oh,
The name is not given, but it simply says that it's nearby the market, that house.
What is the distance? Was it 100 meters? Was it 2? Was it 50?
It's not there, Lordship. The distance is not given. Only it's the witness state that it's nearby nearby the market. He
Nearby-
escaped to the relative's house,
Nearby is a
Islam
very,
Haq, which is
nearby
nearby
is a
the
very
market.
big term. No?
Which is nearby the market.
Nearby means it has to be. You see, some when cases of when the cases which are serious, as this present case, the investigation should be thorough, precise.
That.
Because now we have the issue of plea of alibi.
Plea of alibi also. It must be mentioned in the FIR, Lordship. I'll just go to the FIR, Lordship. FIR at page 2.
The IO should have noted it in his report. Because that would be the PO.
Pushkuni Para. Pushkuni Para, names of the place. Pushkuni Para. It's Pushkuni Para.
Okay. The incident started at, what's the place called?
Khalitan Market.
Khalitan.
It started Khalitan Market, and then he escaped and ran to his the house of his relative nearby the market, which is the place which is called Pushkini Para.
Pushkini.
Pushkuni Para. Pushkuni Para.
One word. But you cannot say how far it was from.
No, it's not given. It's not there. Lord. How far?
Excuse me. Yes.
And PW2. PW2 is the eyewitness. This eyewitness stated that he saw the 4 persons.
Page
21. Page 21. PW2.
Yes.
He states that he saw four persons were running and chasing the victim. And when he entered the house of one relative, they also followed him and entered in the house. And there they assaulted him. And there the victim was assaulted in the room. And after that, after assaulting him, they left him there and they escaped.
Was he able to identify those 4 assailants?
In this deposition, he has given the name of Abdul Khalil. Abdul Khalil.
Only Abdul Khalil.
Only Abdul Khalil, but he stated that 4 persons were running after him. But he gave the name of only one accused person, Abdul Khalil. And when he entered the room, 2 of them entered and assaulted the deceased person, victim. And PW3. PW3 lot, page 23.
PW3.
PW3. This PW3 also states that from his house he saw the Abdul Khalil and 3 persons were running after the deceased person. Abdul Khalil and 3 other persons were running after the deceased person and chasing him. And same, when he entered the house, they also entered the house and they closed the door and assaulted him in the house, inside the room.
Yes.
and he stated that Abdul Khalil and his son entered the room, and he saw that two of them were beating the, attacking and assaulting the victim. So it means that the other accused persons, they were outside. They were outside. They did not enter the room outside. And PW4 also, it's a eyewitness.
Yes.
This witness also stated that all the four accused persons were chasing the victim.
Yes.
All four accused persons chasing the victim. And they chased him and entered in the, and followed him inside the room, and they attacked him inside the room.
Yes.
And this witnesses, he has mentioned all three of them. He has stated all three of them were chasing and following the victim. And also, lastly, he has mentioned all the name of the accused persons. Page 25, Lordship. Lastly, he mentioned the name of all the accused persons. And he said he can identify the accused who assaulted the deceased, and he mentioned all of them.
Yes.
He says that he can identify all the accused persons and mention all of them. From the evidence of the witnesses, Lordship, it is clear that this accused person, he was involved in the offence, to the extent that he took part in in attacking the victim at the first instance. In the marketplace, and thereafter they were chasing the accused person, and when he entered the house also, they were chasing him, and two of them entered the house and attacked. So to that extent, the involvement of this accused is there. He was present. Present means they were present at the place of occurrence. PW5 is the seizure witness. Seizure witness only there. And PW6 is the doctor who conducted the post-mortem. In his cross-examination, he states that it is not a fact that the injuries sustained by the deceased cannot cause death. It means that the injuries are sufficient to cause death. And as per the post-mortem report, at page 47.
Yes.
Type copy. Type copy at page 65. Type copy page 65. the finding or the opinion.
Yes.
Page 65. Page 65, opinion. Probable time since death between 24 hours to 26 hours. Then immediate cause of death, hemorrhage and shock. The cause of the death is due to head injury caused by heavy blunt object.
Yes.
And C, all the injuries are ante-mortem. That means ante-mortem means sustained before death. So as per the post-mortem report, the victim died due to the head injury caused by a heavy blunt object and also the hemorrhage and shock.
Okay.
TIP was also conducted and the one accused was identified. Abdul Khalil was conducted.
This murder weapon was seized.
Seized, Lordship, seized.
From the PO.
Seized, yes, from the PO. From the PO.
Any forensic examination?
No.
No traces of blood.
The evidence of the IO is there, Lordship. Traces of blood is there, not, but it was not sent for FSR. Evidence of IO is there. Page PW8, page 35. Page 35. Type copy is at page 37.
Is the IO?
He's the IO. I have received someone to give evidence. On 13/7/2016, the complainant Shri Shahadat Ali, son of Hashim Ali of Pushkinara under Fulbury Police Station, West Garo Hills, lodged a written FIR to the effect that on 12/17/2016 at about 8 p.m., while Bodial Sheikh, Okil Sheikh and Jahadur Sheikh obstructed his way and attacked him, and somehow he ran away to his relative house, namely Islam Haq of Pushkinapara, but the accused person followed him and assaulted him by a lathi, traditional wood for pounding rice, due to which he received head injury. I have seized a lathi which is used to crush rice, which is about 6 to 7 feet in length. Exhibit 2 is the seizure list, and Exhibit 2/1 is my signature therein. Material Exhibit 1 is the traditional wood for pounding rice, which seized by me. The accused person fled away after committing the offence. The victim was brought to Pulbury CHC, but after first he was referred for better treatment, but around 2 p.m. on the way to the hospital, the victim succumbed to his injuries. Exhibit 5 is the rough sketch map prepared by me of the PO. The PO is visited, rough sketch map PO is drawn, seizure made, eyewitness statement recorded, and section 161 CRPC, and also the seizure witness. The dead body of the victim Bodial Sheikh is sent for post-mortem examination. The post-mortem report that the victim died due to injury caused by heavy blunt object. Exhibit 6 is the inquest report. and Exhibit 6/1 is my signature therein. The statement of the complainant was recorded under Section 161 CRPC. The main accused person, Abdul Khalil, was arrested and TIP conducted whereby the eyewitness have identified the accused who had assaulted the accused person by lathi inside the house of Islam Haq. A prime facie case under Section 341/448/302/34 IPC is found well established against the accused person, Shri Abdul Khalil, Abdul Okil, and Shahanur Islam, all of village Pushkunipara. Exhibit 7 is the charge sheet containing 10 pages filed against the 3 accused persons, and Exhibit 7/1 is my signature. The one in white shirt and long beard is Abdul Khalil, and the other 2 accused persons I could not identify. Cross-examination. At present, I am posted at Special Branch Headquarters Shillong. I was also endorsed to investigate this case by the officer in charge of Pulburi PS. After the case was registered by the OC Pulburi PS, I took up the investigation. The FIR in this case was filed on 12/7/2016. I have seized the stick seized in connection with this case prior to filing of the FIR on 12/7/2006, as because GD entry was made by the officer in charge and thereafter deputed for preliminary inquiry into the case. I have not drawn any formal FIR on the basis of the GD entry. The stick was seized not from the possession of the accused person but from the PO. The stick in connection to this case was not sent for FSL examination. During the examination, I have recorded the statement of Anjana Begum, Jaleka Bewa, and Sulima Khatun as eyewitness, but I do not remember whether I have sent them for recording their statement before magistrate during the investigation. I have visited the PO. I do not remember exactly as to when I visited the PO, but it was after the incident. An inquest was conducted by me. I do not remember how many cuts and injuries were there on the body of the deceased victim, but I have made a report in the inquest report itself. It was seized, but it was not sent to FSL for FSL examination. And identification, only one accused was brought for identification. Only that Abdul Khalil, main accused, was brought for identification. The other accused persons, they were not produced for identification. So that's why the witnesses did not identify the other accused. And PW7 is the magistrate who conducted their TIP. Page 33. Page 33. This is the magistrate who conducted the TIP. Page 33, Lord. I was posted at Tura in the year 2006. I was endorsed to conduct TIP of one accused person at Tura District Jail. There were 3 witnesses, namely Shrimati Sulema Khatun, Shrimati Jalika Bewa, and Shrimati Arjina Begum. The accused were inside the jail, and witnesses was kept outside the gate, and the suspect was made to stand in the ratio of 1:8, and the witnesses was kept in a separate room where the suspect could not see the witnesses, and the witnesses was made to identify the suspect through a peephole on the gate which separate the suspect from the witnesses. The witnesses were able to identify the suspect. The TIP was conducted in the presence of the jailer, the head warder, and both the witnesses put their signature in the column of witnesses. The name of accused person of this case is Abdul Khalil. Exhibit 4 is the TIP, and Exhibit 4/1 is my signature thereon. I have conducted many TIPs, so I could not remember the accused person.
Where's the Seychelles?
Seychelles. Seychelles, page 42. page 42. Type copy at page 43. Description of seizure. One stick which used to crush rice, traditionally of length about 6 to 7 feet approximately. Seized on 12/7/2016 at the PO. Then DW1, DW1, not page 78, DW1. DW1. This is the witness, defense witness. Page 78. 78. This witness state that Abdul Okil means this present appellant.
Yes.
Abdul Okil was with me at around 11 a.m. He was with him at around 11 a.m. But the incident occurred in the morning at 8 p.m. So he did not say where the whereabout of the accused person before 11 a.m. So it means that this witness is not so reliable.
Yes.
He did not say where the present appellant was before 11 a.m. in the morning.
Sentence.
Incident happened at
8 a.m. in the morning.
There the first sentence says that he was there in Magalpura.
So, Lordship, from the evidence of this of the eyewitnesses PW2, PW3, and PW4, it is very clear that the accused person, the accused person, he is involved in this offence. He is involved in this offence to the extent that he participated in the assault at the first instance in the marketplace. And thereafter, when the victim he managed to escape, he ran after the victim, and they were chasing him. He was chasing him along with the other accused and the main accused. And when he entered the house, two accused persons entered and assaulted him. But this accused person, it seemed he was outside, so he was very much present at the place of occurrence. So his involvement is it can be concluded that he is involved. He is involved to that extent.
Yes.
So it can be drawn that this common intention in respect of this accused person. So he is it is present common intention. Although not direct involvement, although from the evidence it is not clear, but he was present there from the time it started until till the time when the accused person or the victim entered in the house of that relative. So the point of argument is common intention only. One point of argument is only that common intention. My submission is that the common intention is there. Common intention is there. This accused person also involved. Although not directly, Your Lordship, but to that extent.
Yes.
And in the post-mortem report, the duration that it's given. Post-mortem report, page 47. Page 47. Page 47. That could be page 65. This incident happened on the 12/7/2016. 12/7/2016. Post-mortem conducted on Post-mortem conducted on 13/7/2016. 2016. And the probable time since that is between 24 hours.
Post-mortem conducted on?
Post-mortem conducted on 13/7/2016 at 11:25 a.m.
So next date.
Next date. Probable time since that is between 24 hours from the time of that post-mortem conducted within 24 hours. And all the injuries also are ante-mortem, sustained before that. So my submission is that this accused is also involved. That is my submission.
Maybe please, Your Lordship. Your Lordship, that. So, Your Lordship, other aspect 313, as Your Lordship knows, that is not an empty formality. So, in fact, I have skipped off at page 70, if Your Lordship permits me. Page 70, Your Lordship, 313.
You did not say anything about 313?
313. Page 70.
70.
Yeah, 313.
You had made reference to 313.
Yes.
313.
Earlier you had made reference to.
No.
I skipped off. Somehow I skipped.
I thought
I'm so sorry.
No.
I'm sorry.
313 was not mentioned.
First Lordship, in the other case I made, I'm so sorry. I'm extremely sorry. If I'm permitted to read little bit, Your Lordship. Page 70, Your Lordship. P3 deposed that on 12/7/16 at about 8 a.m. while she was making tea at the kitchen, she heard some noise from outside, and when she looked outside, she saw Sri Badilal Sheikh was running. Accused Abdul Khalid along with 3 other persons were following him. The victim Badilal Sheikh entered the house of one Islam Haq, and along with the victim accused Abdul Khalil and his son also entered inside the house and locked the door. Son and the father entered, Your Lordship. This is very important.
I think we will not be able to take up the other cases. Because we have a meeting after this. We'll pass these orders. We'll fix the dates at 1 week, 2 weeks, 3 weeks, we'll see.
May I continue, Your Lordship? victim accused Abdul Khalil and his son also entered inside a house and locked the door. When she rushed to the spot to see what is happening, she saw from window of the house that both accused persons were beating the victim Badilal Sheikh with a stick which is used for crushing rice traditionally. As they were unable to enter the house, so they just shouted from outside to stop beating the victim, but they did not listen. When the accused finished beating him, they opened the door and pushed the victim outside, where he fell and lay down on the ground outside the house, and the accused fled away from the scene. PW4 deposed that on 12/7/2016, when she was preparing tea at home, she heard shouting of some people outside the house. So she went outside the house and saw that one person was running, Budullah Sheikh. Behind him, 3 persons were running after him. The person who was running entered the house of one Islam Hawk, and the persons who were running after him also entered inside the same house and then locked the door from inside. She heard them beating the dishes, and from the window of the house, she saw that the 2 persons were beating up so-and-so Sheikh with a lathi, by a lathi. She deposed that they beat the dishes with a wooden stick used for grinding rice. When they finished beating him, they opened the door and pushed the victim out of the house, and they fled away. They fled the scene. She deposed that the persons who assaulted accused Abdul Khalil, Akhil, and you. What do you have to say? Answer very important. On the day of incident, I had gone to Rangsai. As I was walking as a driver, I have been falsely implicated in this case, in state case. I have not assaulted the dishes. With DWS, it corroborates the statement, Your Worship. Then PW6, next question 2, deposed that she have observed injuries on the dead bodies. These are all the doctor's things. He answered that I cannot comment on how the disease died. Then, do you have any? Then she said, I have been falsely implicated in this state case and was present at the time of incident. Then, adduce evidence, he adduced. Your Lordship. Then, similarly, next also, page 72, Your Lordship, 313. The answer is same thing, Your Lordship. On the day of the on the particular day, I was not in my village, but I had gone to Magalpara for my walk. I have been falsely implicated in this instant case, Your Lordship. Then same thing, they say how they did it, I do not know. Implicated falsely, not present at the time. So 313 is not an empty formality, Your Lordship. What evidence come, they clearly stated and they produced in their defense. But the trial court said it is unreliable. And you also will go to a trial court judgment. If you'll also allow me, if time permits, I can go to right now also and point out each and everything. Your Lordship,
you have to
yes.
you have to
Your
point
Lordship,
out
what happened? Trial court is relying heavily on the dog identification. And others, they didn't say that they are outside, standing outside, Your Lordship. Whether period 2, 3, 4, whatever IHS is. They said 3 to 4% chase. They didn't say I have chased, but they have implicated us due to the first informant who wrote the FIR. He had some grudge, probably, of course, that has not come into evidence from the family I come to know. That didn't come, so I cannot say that. So, in the market, who confined, who assaulted, that is not seen. Nowhere in the evidence. No witness to that effect, you see. Now the witness comes that the son and the father entered the house. How I am implicated, Your Lordship? Where is my common interest of? I really doubt, Your Lordship. So, before the Your Lordship, I can say some decisions are there to the effect. If Your Lordship, let's give the decision.
This is on 313?
Yes. No, not 313. 34. Common intention. Just for common intention, they rope in.
Yes.
Your Lordship, have it. Then I go by Balu, LS Balu Subramaniam versus State on 16 October 2015, Your Lordship. 2016-15 SSC, page 471, Your Lordship. I've given this.
2016?
This Balu,
This one.
Bal Subramaniam versus.
What is the citation again?
Citation in the middle is read 2016, volume 15, SSC 471.
Yes.
At page 3, Your Lordship, paragraph 19, Your Lordship, if Lordship permits me to read that.
Yes.
9. In the fact and circumstance case, whether the High Court was right in finding that the appellant acted in furtherance common intention in committing murder of so-and-so, whether the High Court was right in attributing constructive liability to the appellants while convicting them under Section 302, read with Section 35 PC, is the point falling for consideration. 10. To invoke Section 35 PC, it must be established that the criminal act was done by more than one person in furtherance of common intention of all. It must, therefore, be proved that, number one, there was common intention on the part of several persons to commit a particular crime. It is absent, Your Worship. It is absent. Number two, the crime was actually committed by them in furtherance of that common intention. Where we have committed crime, Your Worship? We are not present even. The essence of liability under Section 35 says simultaneous conscious mind of persons participating in the criminal action to bring about a particular result. Minds regarding the sharing of common intentions get satisfied when an overt act is established qua each of the accused. Common intention implies pre-arranged plan and acting in concert pursuant to the pre-arranged plan. Common intention is an intention to commit the crime actually committed, and each accused person can be convicted of that crime only if he has participated in the common intention. Then, Your Lordship, we have discussed some other cases also, about 2004, then Privy Council also they have discussed. So, Your Lordship can come to accuse. Let me come straight forward to paragraph 16, Your Lordship.
Paragraph 16.
Paragraph 16, Your Lordship. Facts and circumstances of the case show that the attack was not a premeditated one, nor was there a prior concert. Initially, settlement talks were on, and fight started only when the accused party was informed by their person that Anand was cut by a complainant party, and thus the incident arose suddenly. No doubt, common intention can develop even at the spur of the moment, but in the present case, the way the occurrence took place, as depicted by the prosecution, there could not have been a common intention between the accused. The totality of the circumstances must be taken into consideration in order to arrive at a conclusion that the appellant had a common intention to commit the offence under which they were convicted. The appellant were not armed, and admittedly they are said to have removed sticks from the bullock cart standing nearby. And on the extortion by accused number 1, Giri, the appellant have attacked Ramesh. There may be similar intention in the mind of the assailant to attack, but it cannot be said that appellant have acted in furtherance common intention to attack the constructive liability under Section 34. The fact and circumstances, in our view, do not give rise to the inference of pre-concert. So my respectful assumption here, there is no pre-concert, nothing meeting of mind. No one has seen that we are together at all. There's a false implication, Your Lordship. So this is one decision, Your Lordship. Then 17 is important for us, Your Lordship. For conviction of what is to be looked into, that paragraph 17,
yes,
Your Lordship. That's important. So similarly, next decision, Jasdeep Singh, Jesu versus State of Punjab, Your Lordship. 2nd January 2022, the citation. Which citizen? This is Supreme Court Criminal Appellate Jurisdiction, Your Lordship. Where citation is? I'm so sorry. Huh? If Your Lordship, for the brevity, I can just give the paragraph here.
See,
paragraph 15, 16, 19.
So, Mr. Vanta, time and again I have requested the parties.
Yes, sir, to give this.
Not to bring out this, this judgment from this Kanun. Because sometimes
Yes.
when we
it's-
compare here
Yes, yes.
and the journals, SEC or otherwise, there are.
Yes,
some
I also
mistakes.
observed that. Anyway, I may be excused for that.
Cannot be.
I shall give the SSC citation. Yes,
But if you give that, then you have to cite.
Yes, then I
you
shall-
have to
I shall
cite the
submit.
relevant paras,
Ah.
which will not match here.
No, I'll cite the SSC citation. I'll print out and I'll give it to you. If Lordship permits that,
Please do.
I can do that.
Do.
I'll give it to you. Only 3 citations I'm relying on. I shall give it. Huh? I'll give the copy.
Or you'll not do, or not now.
I think by tomorrow we can.
Because any authority that you are relying,
Yes, I shall give it from the.
they have to be given opportunity to revert.
I agree.
To
Absolutely.
rebut.
Then if your Lordship permit, all the citations, although they have printed this, anyway, I'm sorry. Other actually equivalent citation is there.
Okay, we'll continue next week then. We'll continue next week.
Next week.
And you can.
If I, just to give the citation only, I'll just sign it, Your Lordship.
You can give
Because
us
9th, I think
he has to reply.
Oh, yeah. I'll give the copy.
Because he has to reply on 313.
Yes.
And others.
9.
Yes. Yes.
And I'm sorry for this. I'm extremely sorry.
That's okay. But it's, you see, it should be your duty to assist the court. Otherwise, when we are confused and we give a wrong judgment, then you
I
will.
understand. In
whom
fact,
to be blamed?
it's my mistake.
You
In
have to
fact,
blame
I should
yourself.
have told them. My mistake. I'm sorry.
It's
Extremely
okay.
sorry.
Heard Mr. S.P. Manta, the senior counsel. Also heard Mr. H. Karni, related additional LP. Hearing will continue on the next date. This is matter on 9th.
That's all. And I'm deeply obliged by good news.
Any first in the list?